that any testimony you give today shall be the truth, whole truth, and nothing but the truth, so help you God?
Yes, sir.
Thank you. Please proceed.
Good morning. Can you please introduce yourself to the jury?
I'm John Borglum.
And did you know Michael Shaver?
Yes, I did.
How did you know Michael Shaver?
So I was Michael's leader at Disney for a few years. He actually worked for me on 2 occasions. First time was when he was in his 4th year as apprenticeship in a monorail shop. So that was from roughly August of 13 through August of 14. And then in 2015, or in 2014, he transferred to Epcot when he completed his apprenticeship. I also transferred to Epcot in April of 2015, and that's where Mike worked for me again.
When you refer to yourself as his leader, is that basically a supervisor?
Yes, sir.
And in order to work as a mechanic at Disney, what did he have to do to get that position?
So Mike actually completed a 4-year apprenticeship as a mechanical apprentice in order to be able to work at Disney, and then also complete an exam in order to be able to work as a attractions mechanic in one of our attractions.
And how was he performing as an employee?
Mike actually performed really well. Was not happy on a personal aspect when he transferred to Epcot from the monorails, because I was at monorails, I wanted to keep him. But I was really happy when I transferred to Epcot and he was once again working for me.
And when in the course of the time that you were supervising him, was there ever any discussions of his advancement within the program?
Yes.
Judge, hearsay.
Sir.
Hearsay.
All right. Overruled.
So I was actually, in late 2015, I was actually ready to promote Mike to a working foreman position, which would have involved a pay raise, and that was primarily due to his work ethic and the way he was respected by the teams.
And had you made him aware of that consideration?
Yes, sir.
Now, as a mechanic at Disney, specifically when he went through the apprenticeship program, was he issued tools by Disney?
So there is a small set of tools that are issued by Disney. It's just a standard set that they're issued. However, each cast member is allowed the opportunity in order to be able to purchase and bring in their own set of tools. So those tools are can also be generic ones or specific for whatever task it is that they are performing in the attractions.
And even the tools issued by Disney once he completes the apprenticeship program, do they then belong to the individual?
That I don't recall.
No. Now, does Disney maintain records of employment that include absences, whether or not someone called in sick, didn't call in when they were absent, things of that nature?
Yes, sir.
I'm going to go ahead and show defense what has previously been marked as State's Exhibit U, proper business record certification, business records from Walt Disney work, Michael Shaver.
Judge, we're going to object to the objection, or to the certification, excuse me. The records are just improper bolstering at this stage. They're not relevant and probative. This witness has no probative testimony other than to try to bolster a man who's not here before. It's not probative pursuant to Smith versus Carlisle and Volker as well that I've cited to the court.
All right. State's response.
Any sort of objection to the business record certification is untimely, as that was not done for the business record certifications for these Disney records were not done prior to trial. And we are going to be talking about his attendance records, which are contained within.
It does not alleviate the relevancy, whether or not there's an objection made prior to trial or not. The state still has to show the probative value, irregardless of whether they want to introduce it. Under Smith versus Carlisle and Volker, it's not probative evidence to just bring a man in and try to bolster somebody's testimony to try to throw some ammunition out there on behalf of the state. Again, it's not probative in any matter.
Anything further?
No, sir.
Objections overruled.
States move in states U into evidence as states number 9.
States U will be admitted into evidence as states number 9.
Now, Mr. Borglum, prior to your testimony here today, have you gone back and reviewed Mr. Shaver's attendance records during the time frame that he was working at Disney?
Yes, sir, I have.
All right. Now, I want to take you back to November of 2015. Was Michael Shaver scheduled to work on November 10th, 2015?
Yes, he was.
And, Your Honor, I would ask at this time to publish the contents of states number 9 to the jury.
Judge, whether he was supposed to show up for work one particular day does not alleviate or does not answer the question.
Can we approach?
All right, let's have a sidebar. Thank you.
Borglum, I'll direct your attention to the page that's numbered on the bottom. That's 986. Do you have that page in front of you?
Almost.
Okay.
986.
Now, on November 10th, 2015, was Mr. Shaver scheduled for work?
Yes, he was.
And did he show for his scheduled work?
November 10th, he's actually documented as a no-call, no-show, which
What
means,
is that?
so no-call, no-show means he was scheduled for work and he did not call in, whether it be call sick, call whatever, in order to let us know he was not coming into work.
And what was his next shift after November 10th, 2015?
So it would have been November 10th, which actually would have been his first day coming back to work after his 2 days off. So November 10th, 11th, 12th, 13th, and 14th. So there's 4 consecutive no-call, no-shows.
And all of those are reflected in the records that you're referring to there?
Yes, sir.
And the going back through his attendance at Disney, had he ever no-call, no-show for work before November of 2015?
No, he had not.
I'll just quickly go through those records, appearing on page 97, 98, 99, 990, 991. The first entry there on page 991 as far as the time frame that Mr. Shaver was working with Disney, where there was something on his attendance.
The one for 926?
On
Top one?
the date on 991 showing
The date on 991, the very first entry is 8/31/2009.
so in that 6-year period prior to November of 2015, no call, no shows.
That is correct.
Once Mr. Shaver had failed to appear for work and didn't call in, first of all, was that concerning and unusual to you based on his prior experience?
Yes, it was.
And so what did you do?
So the first night, I would have actually asked the team members who know Mike best if they knew something was going on, if he had reached out to any of them, and I would have sent him a text message.
Did you ever call him on the phone?
Not the first night.
And how were you communicating with him then?
At that time, it was via text message.
And did he or someone in possession of his phone correspond back with you?
On the 13th was actually when I received a text back, because by the 13th, that had been 3 consecutive no-call, no-shows. By Disney policy, 3 consecutive no-call, no-shows. It is a automatic termination of employment with a company. So I had been texting and trying to call his cell phone in order to find out what was going on, as well as if there was issues, in order to offer assistance, because Disney does have Disney Assistance Program, where if things are coming up, we're able to help out, especially for outstanding employees. So I had reached out to Mike, and on the 13th is when I got a text message back. The text message stated along the lines of,
Objection, Judge, we can approach.
All right, sidebar, please.